Hello and welcome back to the channel. Today I want to talk about a SCOTUS decision on West Virginia versus EPA and how this is actually a Second Amendment case. Let's find out. All right, and this is the second, the additional ruling that came out from the Supreme Court, and this was the West Virginia versus EPA ruling. And this is going to have an impact on additional things, and it relates both to the Second Amendment and relates to just the general amount of power that not the federal government has, but federal government agencies.
Talk about the Supreme Court's ruling in the West Virginia v. EPA case. In this case, the Supreme Court issued a 6-3 opinion authored by Chief Justice Roberts. The question in this case was whether Congress gave the EPA broad authority to regulate power sector greenhouse gas emissions, or is the agency's authority to regulate more limited? Well, this decision by the Supreme Court found that Congress did not grant the EPA authority to regulate greenhouse gas emissions in virtually any industry however they want. Now, although this case dealt with the EPA as an agency, this case and ruling has much broader impacts. Really, this is about what authority do executive agencies have. In reaching their decision, the Supreme Court said this case involved the major question doctrine.
Okay, so this is the important point. He's going to talk about major question doctrine versus Chevron deference. So what was happening before is a lot of these agencies, again, were using Chevron deference, which became a bit of an easy crutch for the courts to weigh the needs of the governments against the rights of the individual in this case. So basically, this became the federal government agency hammer. And anytime an agency wanted to do something or change something, this has been kind of a recent trend, they would just reinterpret their mandate and reinterpret the law that gave them their powers in the first place, and then decide, well, we're going to redefine this as meaning this, and we're going to redefine that as now meaning all of these other things. And so now we have the power to regulate something that we previously decided we did not have the power to regulate.
Congress frequently delegates authority to agencies to regulate particular aspects of society in general and broad terms. However, in a number of decisions, the Supreme Court has declared that if an agency seeks to decide an issue of major national significance, its actions must be supported by clear statutory authorization. Courts, commentators, and individual Supreme Court justices have referred to this doctrine as the major question doctrine or the major rules doctrine, although the court has never expressly used that term in a majority opinion until now. Under that doctrine's terms, administrative agencies must be able to point to clear congressional authorization when they claim the power to make decisions of vast economic and political significance.
So that's huge. It states that the major question doctrine, as they're applying it, is that they require the agency to have clear congressional authorization for decisions of vast economic and political significance. I like that they threw that in there because a lot of this stuff is politically driven. And so even if it's not necessarily a economic or a large economic decision, which could have limited the scope of this, saying that it has that it applies to things of large political significance kind of opens it up. And that's a good thing because there are many decisions that are driven politically that may not be huge financially. You know, that just seems like something that could be argued ad nauseum. So I just like the fact that they sort of put in a backstop there, which was the political significance as well, because again, a lot of these decisions are politically derived or politically originate politically, and I will discuss that more in a second.
The court traditionally has treated the major question doctrine as an exception to the Chevron deference doctrine. Chevron deference and that doctrine governs judicial review of agencies' interpretations of a statute. If Chevron applies, a court will typically engage in a two-step analysis to determine if it must defer to an agency's statutory interpretation of an ambiguous term or statute. At step 1, the court asks whether the statute directly addresses the precise issue before the court. If the statute is...
Usually, they won't. A lot of times, these regulations or the specific authorization that they're given is very large and vague, and so it won't address specific situations.
Ambiguous or silent in that respect, the court must proceed to step 2, which instructs a court to generally defer to the agency's reasonable interpretation.
So again, defer to the agency's reasonable interpretation, but you're assuming that the agency is acting reasonably. And as we've seen lately, and specifically, I'm going to call out since, say, 2015, just throwing that number out there, we've seen agencies acting in a distinctly non-reasonable and distinctly politically driven way.
Essentially, under Chevron, if there's an ambiguous statute or term and there's a determination that's ambiguous by the court, then they simply defer to what the agency says. However, under the major question doctrine, when an agency's interpretation of an ambiguous statute concerns an issue of vast economic and political significance, the court must deny the agency the deference traditionally afforded to them under Chevron.
What happened here within just a couple of weeks of each other was like two major blows to these sort of two-step approach, Chevron deference approach to different questions. The first one was in relation specifically to the Second Amendment. This second one was in relation to regulatory agencies, but that also has application to the Second Amendment because we do have regulatory agencies that regulate firearms, don't we? Okay, so outside of that, we've kind of seen the Supreme Court squash that down, and I think that's good. What I see them doing is pulling the reins back on these federal agencies and saying, no, you really, you're reinterpreting your mandates, you're reinterpreting what these mandates mean in order to, drive for some economic or political purpose. And as a result, we're going to pull back on that. You really need to have a clear congressional authorization if there's something of big economic and political purpose. So now I want to go to the next thing. And this particular ruling actually has an impact on the car community. So you will see in this Jalopnik article that was originally published back in 2016. Again, there comes that period of time starting in 2015 where things got really interesting and all of a sudden agencies started, filling their oats and deciding that they were going to reinterpret and come up with new rules. So the EPA, our rules on pollution, specifically air pollution, don't apply to these like small niche segments like, say, race cars. These are cars that are not street legal. And then all of a sudden they said, no, our greenhouse gas emissions and other things, suddenly that applies to racing vehicles as well. Well, I mean, if you know racing vehicles, it's a sport, okay? And these vehicles get terrible gas mileage. But they literally race like one day a week, and there's maybe, 50 to 100 of them on a racetrack, and that's it. Is that, significant compared to literally hundreds of millions of cars that are on the road? This represents 0.0001% or something like that. It's such a small amount, it's never going to amount to anything, right? You have street legal cars, and having that definition, the purpose of having that definition is so that you know that these types of rules apply to that. And then these non-street legal cars, which don't run on the roads normally and have a very special and specific purpose, they're a very small number of vehicles, and they only run in very specific circumstances, like, for example, track cars. You can't just drive them anywhere. You can only drive them on a track. So let's just go through it. Will a proposed rule from the Environmental Protection Agency really hinder your plans to turn your daily driver into a badass track-only machine, right? And it will, officials from Aftermarket Trade Association, SEMA, and the EPA itself confirmed to Jalopnik. So last night, SEMA announced a pending EPA rule that in interest of reducing greenhouse gas emissions would basically prohibit conversion of vehicles originally designed for road use into race cars. It would also make the sale of certain products for such vehicles illegal. And this is where we get into the big economic impact, because aftermarket car parts is a huge industry. And when you start basically saying we're going to take a large segment of this aftermarket car parts and make them illegal, then you are having a big economic impact. Now, is this politically driven? I would say for a up to a point it is. Obviously, I think everybody wants to have clean air, but there's going to be debate over the impact of a bunch of race cars on greenhouse gas emissions and whether their impact is actually significant in any way. And let's say we turned every race car into greenhouse gas emission free, like carbon neutral, even if we made, let's assume this, let's assume that tomorrow, starting tomorrow, all race cars everywhere were greenhouse gas carbon negative. They somehow soaked up carbon. Would that even have an impact on global warming? I think we know the answer to that question. All right, so in truth, SEMA's contention has to do with EPA's clarifying or changing, if you ask the association, a long-standing provision in the Clean Air Act, which for decades pretty much ignored the emissions of non-street legal race cars. So this is exactly what we're talking about. This is exactly what the major question doctrine is about. It's about an agency reinterpreting their mandate without clear congressional authorization and deciding it now means this. Now, who else does this a lot? Obviously, the ATF. They've been reinterpreting a lot of things lately. They've been reinterpreting things so that they could say get rid of bump stocks, or so that they can, now they're pursuing frames and receivers. So, this is going to have a big impact on those things. But let's look at other areas where this has had an impact. So that this isn't just related to cars. This also affects other industries as well. So you may recall the waters of the U.S. expansion that happened under a certain president, and the EPA again decided that suddenly their mandate was, well, larger than it was. If we want to look at the original waters of the United States definition, the original definition was navigable waters. Okay. Navigable waters, that seems like, and waters that pertain, say, to trade and economic activity. That's what it covered. But then suddenly, out of nowhere, in 2015, they decided that no, it actually applied to navigable waters and any adjacent waterways. And sometimes, even if those adjacent waterways or tributary waterways weren't actually holding water. So now imagine a farmer who, is just a guy with farmland, and suddenly he needs to do a full environmental impact study just so he can go plow his fields. Well, it's hard to be a farmer then if that's the case. Where do we go from here? Well, interestingly enough, this 2015 Waters of the U.S. rule actually got rolled back. Now they're looking at reinstituting it again. This was actually like a little bit of a godsend for a lot of people when the EPA pulled back on this. And now they want to take another crack at it, basically. But if you've got a dry ditch that doesn't hold water, and then you say, oh, well, that's now going to be considered part of navigable waters because it's adjacent or a tributary. Well, what does that mean? If you think about it, a lot of these areas that got impacted by this were basically just drainage off of land. And, well, I hate to tell you that, but all land has a drainage, natural drainage. It's going to be any low-lying area of that land, and whenever it rains, that's the area where the water runs to. And then it runs somewhere else. And eventually that's going to run into a creek, and then eventually it'll run into a river. But when you expand it to adjacent and to cover areas of land that are basically dry all the time unless it's raining, well, that pretty much expands navigable waterways and adjacent areas to I don't know, the whole goddamn planet. So that's ridiculous. And it is absolutely a huge economic significance to expand this definition. And a lot of it is absolutely politically driven because there's obviously one side that is driving this and claiming that we need this additional regulation. And I know everybody cried a goddamn heart out over when this thing got repealed, and this was going to be the end of the world, and suddenly all our waters were going to be completely polluted, and our water quality is going to be terrible everywhere, and blah 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 blah. But there is a problem with suddenly declaring all dry land to be waterways. And that's about what it felt like. And it's especially what it felt like for many, many different industries. Okay, so you can see that this is going to have an impact also on the ATF. It's going to have an impact on other industries. And honestly, I think it's a fantastic ruling by the Supreme Court. They're basically just saying, hey, if that's your mandate, then that should be in your mandate. So it has to be in there. And if it's not in there, guess who has to put it in there? Congress has to put it in there. Basically, this is the Supreme Court pushing back on the Congress and telling them, hey guys, do your damn job. All right. I think this is a fantastic ruling, and I'm happy to see that this is probably going to be a roadblock to bringing back the 2015 WOTUS, because that was a bunch of BS in my opinion. No matter how many times these people want to convince you that the end of the world is coming, it's not coming. When we didn't get all the internet crap because they didn't get the net neutrality, that was going to be the end of the internet. Remember? Did it happen? No. Do we still have Netflix? Yes. Do we still have YouTube? Yes. And is Netflix charging a premium for people, to have high speed, and a lesser amount for people, with lower quality and lower speed? No, they're not. It didn't happen. Quit listening to these effing idiots, all right? Just quit listening to them. All right. That's it for me today. I am absolutely elated about this decision, and I hope you are too. It's going to have wide-reaching implications on lots of federal agencies, and basically SCOTUS has put the slap down on them and said you can't just do whatever the hell you want anymore. You can't just redefine whatever the hell you want anymore. So I look forward to seeing the impact that this has, not just on the ATF, but the EPA and many other overbearing federal agencies. Hope you enjoyed the video. I'll see you next time.